Honorable Mr. Justice Almas Kabir, Judge of Supreme Court of India, Honorable Mr. Justice E.M. Sahai, Judge of High Court of Allahabad, Mr. Suraj Narayan Prasad Sinha, Chairman, Bar Council of India, Professor Ranveer Singh, Vice Chancellor, National Law University Delhi, Professor A.K. Paul, former VC, NLU Jodhpur, distinguished honorable guests from district administration and judiciary, this honorable district judge, CJM, other members of the judiciary, then honorable members of the district administration, our distinguished dignitaries and guests present today. Good morning to everyone. Sir, I have great pleasure and privilege in welcoming all the distinguished guests and visitors to IPEM campus this morning. As you are all aware, Honorable Mr. Justice Almas Kabir, Judge of the Supreme Court of India, is our chief guest today. I am highly thankful to Honorable Mr. Justice Almas Kabir for accepting our invitation to be the chief guest at this national seminar. Sir, today will become a red letter day in the history of IPM by your kind presence here. Your presence is a source of inspiration and is going to motivate all of us. Sir, we feel obliged that in spite of your busy schedule, you have been able to spare your valuable time and kindly grace the occasion here. I welcome Honorable Mr. Justice Almas Kabir, Judge of the Supreme Court of India, to this institute. Thank you very much. Faculty and the staff members at this institute, thank you very much, sir. Mr. Suraj Narayan Sinha, Chairman, Bar Council of India, is also our guest of honor today at the today's function. We are thankful to Mr. Suraj Narayan Sinha, Chairman, Bar Council of India, for accepting our invitation and coming here for the function. I welcome Mr. Suraj Narayan Sinha, Chairman, Bar Council of India, to our institute. Thank you, sir. As you are aware, Professor Ranveer Singh, Vice Chancellor, NLU Delhi, has kindly accepted to give keynote address today. Keynote address is of very great importance in any seminar. That keynote address will give us the guidelines and some points direction how the deliberations of today's seminar should be there in the later sessions. So we are thankful to him. Sir, we are obliged and thankful to you for your this kind gesture, and I am sure your valuable advice, guidance and direction will go in a long way in further improving the performance and standards of IPM Law Academy. I welcome Professor Ranveer Singh, Vice Chancellor, NLU, New Delhi, to this institute. Thank you. I also take this opportunity to welcome Professor A.K. Paul, former VC, National Law University, Jodhpur, who have kindly come here to grace the occasion. I welcome him to this institute. I also welcome to other distinguished guests from the Ghaziabad judiciary, from Ghaziabad administration, as well as other dignitaries of the city. Then visitors, delegates and participants who have come today by sparing their valuable time. I am sure their participation will contribute a lot in making this seminar a success. with the presence of all honorable dignitaries who have spared their valuable time to kindly come and grace the occasion of this august gathering, myself and on behalf of all the personnel of IPEM group of institutions, I can convey our heartfelt sincere thanks and gratitude and assure you, sir, that your advice, guidance and directives will be followed in the letter and spirit by all concerned at IPM Law Academy so as to enhance our standards further. Lastly, I convey my appreciation and congratulations to the Principal of Law Academy, Dr. Mamta Srivastava, and other faculties, staff and students of IPM group of institutions to organize this seminar, and we wish them all success in this venture. I wish again and once again convey my sincere thanks to all the dignitaries and delegates for their participation and wish them a comfortable and productive stay in the institution. Thank you very much.
Dignitaries and speak a few words. Sir.
It's a matter of great honor and privilege of District of Ghaziabad that the eminent jurist of this country, Honorable Mr. Justice Kabir, Judge Supreme Court of India, and Honorable Mr. Justice B.M. Sai, Senior Judge, Allahabad High Court, have spared their valuable time to spare their vision on the subject of this seminar, Justice Delayed, Justice Denied. I, on my behalf and on behalf of the whole district judiciary of Ghaziabad, welcome your lordships. I am happy to reveal that it has always been our endeavor to ensure that cases are taken to its ultimate end in logical manner as early as possible, in spite of the multiple hurdles in debate. But it is a hard time to think, is the judiciary of this country is only responsible for this? Is not providing funds and infrastructure by the government for creation of courts as directed by the apex court from time to time is not a major cause for this problem. For example, in the Honorable High Court of Allahabad, the sanctioned strength of the honorable judges has been enhanced from 95 to 160 few years ago. But still, the sanctioned strength could not be given effect for want of funds and infrastructure. In a recent judgment delivered by the Division Bench of Allahabad High Court, it has been observed that even if today filing of criminal appeals is stopped, at least 300 years will be required to clear the docket. It has been further observed that it is due to establishment of fast-track criminal courts in subordinate courts, but not increasing the number of judges at higher level. However, this seminar and presence of the lordships here in the district and in this seminar has inspired the whole judiciary of Ghaziabad to do a lot for the betterment of litigant public by giving them their due as early as possible within the limits of law. I also welcome all the guests and dais, and in front especially Sri Sinha, Chairman BCI, Professor Ranveer Singh, Mr. A.K. Kaur, Mr. S.P. Singh, and all distinguished jurists, lawyers, teachers, and students who have come over here from different parts of the country. I am sure your contribution to this seminar will be significant value. Thank you for being here. I also thank IPEM Law Academy for organizing such a big event and being able to attract so many jurists and experts. I wish this seminar is a good success. Thank you very much.
Thank you so much, Honorable Justice Mr. B.C. Gupta. I am now honored Professor Mamta Srivastava to come up and felicitate all the guests and speak a few words. Thank you.
It is indeed a matter of great pride and privilege for all of us at IPEM Law Academy to welcome all of you this seminar on Justice Delayed, Justice Denied. I am greatly delighted to have very distinguished guests at IPEM. In particular, I want to extend a very special welcome to Honorable Justice Altamas Kabir, Judge Supreme Court of India. Very special welcome because who has kindly consented to inaugurate this seminar. We are very grateful to Honorable Justice Kabir to have graced this occasion today despite being Sunday, which legitimately belong to his family. We apologize to his family of having denied them this right. Justice Altamas Kabir was born on July 19, 1948 and had his education first in Calcutta Boys School and then in Presidency College. He graduated from Presidency College with honors in history and then passed away from Calcutta University in history. Subsequently, he obtained degree of law from same university and enrolled himself as an advocate in Calcutta High Court in 1973. After starting his career as an advocate, he never looked back and moved on and on. On the path of success and earned good name and fame, Justice Kabir, an outstanding advocate, has the rare distinction of practicing in all the courts, District Court, High Court, and the Supreme Court, and also in all subjects. His hard work, meticulous preparation of cases, excellent oral and written communication skills, and above all, his humane nature was soon noticed by litigants, bar and bench alike. Judge of the Calcutta High Court on 6 August 1990. He was appointed Chief Justice of Jharkhand High Court on 1st March 2005 and became Judge of the Supreme Court of India on 9 September 2005. Justice Kabir has delivered significant judgments on many vital issues. He was part of the bench which settled the controversy relating to laws put in 9th schedule. Sir, I welcome you on behalf of IPEM Law Academy. I welcome you indeed. We are very glad and feel honored by your distinguished presence here. Your presence here will stimulate law ideas, inspire insightful deliberations, and encourage the delegates also. May I, Dr. B.S. Goel, the campaigner of academic excellence, to felicitate His Lordship, Honorable Mr. Kabir, by presenting a bouquet and show. Please, sir. Thank you, Dr. Goel, sir. It is also a matter of pride for us to welcome our esteemed guest of honor, Honorable Justice Ghaziabad Sahai, Judge High Court of Judicature at Allahabad, a law graduate from Oxford of East, the University of Allahabad. His Lordship, Justice Sahai started practice at Allahabad High Court in 1976. As an advocate, Justice Sahai was studying counsel for UP Public Service Commission, Ghaziabad Development Authority. 29. I welcome you, sir. I welcome you, sir, on behalf of IPM Law Academy and on behalf of all of us here. I now request our director, Colonel A.S. Malhotra, to felicitate His Lordship, Justice Sahai, by presenting a bouquet and also a shawl and memento. Please, sir. Thank you, sir. Lawyers are the key functionaries and members of an independent profession. Without the expert assistance of lawyers on either side of a dispute, judges will find it difficult to decide. The contribution of this profession in dispensation of justice has been admirable, and it is a greater joy for us to have with us Sri Suraj Narayan Prasad Sinha, the Chairman Bar Council of India, as another guest of honor. Mr. Sinha is a veteran in the field of legal profession. He started his practice as a pleader of Darbhanga, a place which has given new dimension to fundamental rights in general and right to property in particular by way of Kameswar Singh's case. He has the uncommon distinction of practicing from lowest to highest judiciary in the country. He was elected to the Bihar Bar Council for 3 consecutive terms before becoming member of the Bar Council of India in 2004. He has taken a number of initiatives to make Indian legal system vibrant and meaningful. Under his able leadership, new education policy for legal studies is under preparation, which will have a direct bearing on dispensation of justice. Now, I welcome you, sir, and request Mr. Anupam Goyal, Secretary, IPM Group of Institution, to felicitate Mr. Sinha by presenting a bouquet and memento. Please, sir. The advantage of being an expert. The advantage of being an expert is that others listen to your perspective. It is a matter of great satisfaction for us, and we are fortunate to have with us Professor Ranveer Singh as an expert of the subject. Keynote. Anyone connected with this legal education knows his acumen. He has held a number of important assignments. Most important of all, however, in his pioneer work in building an institution like Nalsar University of Law, Hyderabad, from its humble beginning to its current international stature. Professor Singh's greatest strength has been his ability to nurture the entire university, community, faculty, students, and administrators alike. The Delhi government and top judiciary of the country could not resist the temptation of bringing him to the national capital. He has been picked up to establish a new law university in Delhi. It has taken off well under his dynamic leadership and soon may come up as one of the best institutions of the country. He has traveled far and wide. I welcome you, sir, and now I request our most popular and senior staff, Mr. Aditya Tomar, felicitate Dr. Ranveer Singh by presenting a bouquet and memento. Mr. Aditya Tomar. There he is. Mr. Aditya Tomar, please felicitate Dr. Ranveer Singh presenting a bouquet. Mr. B.P. Tiwari present हो जाए. Mr. B.P. Tiwari. His vice chancellor said, it was during his time that students started getting internship and placement in foreign law firms. Professor Paul always wanted to bring uniformity and excellence in legal education and profession. With this aim, he started All India Law Teachers Congress, is the founder president of the same. He is the visiting professor of various foreign universities and has authored a number of books. His classical book on WTO is prescribed by almost all the universities of the world and is greatly relied on by international trade lawyers and dispute settlement body of the WTO. His book on UNCTAD is a prescribed reading in London School of Economics, which by itself is a greatest award to an academician. I welcome you, sir, and request our senior lecturer, IPM Law Academy, Mr. B.P. Tiwari, to come on the stage and felicitate Professor A.K. Kaul by presenting a bouquet and movement. Now, I wish to request Mr. V.P. Gupta, District Session Judge, to felicitate Honorable Mr. Justice Altamas Kabir on behalf of Ghaziabad Judiciary. Now I also request Mr. Akhilesh Kumar, the Chief Judicial Magistrate, of Ghaziabad to felicitate Honorable Justice V.M. Sai on behalf of Ghaziabad Judiciary. Please, sir. I request Akhilesh Dubey ji, CGM Ghaziabad, please felicitate Justice V.M. Sahai. Now I request Mr. Siddharth Tyagi, President, Bar Association Ghaziabad, please come and felicitate Honorable Justice Altamas Kabir. Now I request Professor J.L. Paul, Delhi University, please come and felicitate Honorable Justice Kabir. Now I request Professor Surendra Nath, Dean BHU, please come and felicitate his lord for presenting a bouquet. very student, it is very good comment for you. Justice says कि मुझे एक separate car लेनी पड़ेगी सारे बुके लेके जाने के लिए. Okay, those
Professor's call has been associated with imparting legal education to the desiring students. Ladies and gentlemen, Professor A.K. Paul.
Honorable Justice Alkabe, Honorable Justice James Sahai, Professor Ranveer Singh, Vice Chancellor NLU, Delhi, CSP, SNP Sinha, Chairman Bar Council of India, Dr. D.S. Goyal, Chairman of the IPEM, Dr. Srivastava, Principal, District Judge, and other district judges, lawyers, professors of IPM, students, ladies and gentlemen, members of the civil society. It's my proud privilege to be here this morning to speak on a subject, justice delayed and justice denied. Fortunately or unfortunately, the history of the human civilization has all through had this problem of justice delayed, justice denied. And even up till now, we have not found concrete and suitable solutions to the malady of the justice being delayed and justice being denied. It's not the fate of this country alone where we are facing the problem of areas at the court, the problem of justice not of the same quality as we expected or are expecting, the problem of the dispensers of justice not being up to the standards, and so on and so forth. We can name any number of the problems which the justice delivery system is facing, has been facing. I am reminded of Justice Holmes, one of the greatest saying, that what exactly you mean by that justice is delayed and justice is denied? What is justice? How does justice get delayed? And how do you feel that you are being denied justice? His response in the context of the United States judicial system was that if it is the law is what the pretensions of the judge are, then justice necessarily will get delayed. Because you don't have any other mechanism by which you can say that I am going to replace the court system. Whether you like it or whether you do not like it, the formal mechanism of the dispensation of justice has to take the recourse to the court process. Now that court process may be a Nyaya Panchayat, it may be a smallest magistrate executive, it may be the district judge, it may be the high court judge, and it may be ultimately the apex court judge. That is how the process is arranged. No human civilization, down from the Romans down to the present, has ever had the possibility of developing something where we can have, in the present context, a slot machine, put the point and get the justice. It doesn't happen. But at the same time, when we are in the continuity of the human civilization, while we want to have progress, while we want to have inequities to be removed, while we want that the distribution of advantages vis-a-vis disadvantages have been monitored by a system, then what should be the merits of that system? That is where the dispensation of justice has to take care of itself. In that context, I am not going to speak on the areas of in the court, on the type of the judicial administration which we have in the country, because I am going to speak on those issues in my valedictory. Right now, if a list has to be drawn in the context of reforming the legal system, that is the judicial system of this country, important 4 variables are to be taken into account. The first is the Supreme Court of this country playing politics? If so, how they themselves have to avoid that politics? As an academician, I can prove it beyond doubt that the court, especially the apex court, has become a political institution. In what way? They have to devise mechanisms by which their politicization, that politicization has a definite connotation, that has to be dispensed with. That's first. Second is that the institutional hierarchy of the court system ultimately rested in the autonomy of the system as such. The Prime Minister is on record that there shall not be any dearth of or paucity of funds to be extended to the courts. Then, in what way the cases remain on the dock from 30 to 3 centuries? As our judge of the district court has said, that if no case in the criminal side is being instituted, it may take 300 years for removing the areas of the cases in the court. Obviously, therefore, the autonomous structure of this legal system, the dispensation of the judicial system of this country, has to think itself, because it cannot always accuse either the legislature or the executive for not its own promptings by which the dispensation of justice has to be carried to the door of the common man. Third, till this country remains illiterate, the half of the country is illiterate, the dispensation of justice will have its own premiums. Because what happens, that once you are illiterate, you do not know what exactly you mean by your case not getting the due, your rights not be getting the recognition, proper recognition which you want to have. In the ultimate analysis, if this country has to have the justice to be prompt, quick, efficacious, then necessarily illiteracy has to be removed. And how much time it is going to take, that itself has its own limitations. The last and important point, that is in the context of the present day technological revolution, which is happening and has happened throughout the globe, the e-dispensation, the e-justice dispensation system, which has been put in practice in Europe, Indian judicial system needs to have it, and try to explore the possibilities, whether through that e-justice delivery system, we can at least remove the areas from the court. The rest of the points which I will be discussing, that I shall put before you when my turn of delivering the valedictory address is being extended to me. Thank you very much. Thanks all.
Thank you so much, Professor A.K. Kaul. Ladies and gentlemen, it's my utmost pleasure now to request Professor Ranveer Singh, Vice Chancellor, National Law University, Delhi, to please come up to the podium and deliver his keynote address. Professor Singh has played a crucial role in reviving the legal education in the country and recasting it so as to make it more relevant to the contemporary concerns. Ladies and gentlemen, Professor Ranveer Singh.
Honorable Mr. Justice Ahmed Kabir, Honorable Justice Sahai, Respected Mr. Sena, Professor A.K. Kaul, and J.L. Ghaziabad, members of the organizing committee, the other speakers, those who have come, Professor Mamta Srivastava, and other guests, dear students, media, ladies and gentlemen. I feel proud and privileged this morning being invited to be the part of this deliberations, which is a very important seminar on delays in justice. I have many questions to ask from myself and from you as well. The first question is, I ask, why I am here? Am I responsible for the delays? That is my first question. I have answered that question later on. If yes, what is my role and the role of the law schools in the justice delivery system or dispensation of justice? I think we, all of the law schools, have to play a very big role as far as justice dispensation system is concerned. I'm reminded of what Justice Stone said, that the character of the bench is determined by the character of the bar, and the character of the bar is determined by the character of the law school. These all things are complementary. If you want to have good judges, you need to have good bar, good advocates. If you need to have good advocates, you need to have good law schools. Friends, if you know, the chairman of the Bar Council of India is here. We have around 700 law colleges in this country, and most of them are in the private sector. And sir, then we have about 400 universities, and in those 400 universities, which are state universities, central universities, and some of them deemed universities, we have about 30 or 40 law faculties, sir. And then at the top of it, we still felt the need of having the law universities. Why? Answer may be difficult, the answer may be easy. Out of these 700 law colleges, when I go for a NAC meeting and meet the faculty and the organizers of those institutions, I often ask, what do you feel is your ranking in these 700 colleges? Are you in the first 10? The answer normally would be no. So with these 700 law colleges, 130 law faculties, 13 law universities, the big question today is, delay justice is fine, that what kind of lawyers we are producing. We are a great profession. Great profession in the sense that if you look into the history of any country of the world, not only India, you will find the lawyers have been always at the forefront to bring freedom to the countries. They have been a part of the freedom struggle. May it be Nehru, may it be Gandhi, may it be Patel, may it be Jinnah, may it be Nelson Mandela, may it be Lincoln. You have people all over the globe, those who were part of the freedom struggle and who were responsible for bringing freedoms to the countries. And recently you see Pakistan, our neighboring country. The democracy to Pakistan has come not because of anybody else. It has come because of the lawyers. We are a great profession, but there is a big question mark. Incidents like what happened in Chennai, or elsewhere sometime, or when we waste times of the prestigious time, very prestigious times of the court, then we probably need to sit back and think, because these are all things which when the courts are closed for weeks, for months, for merely shifting a court or having a new court building, or for introducing a legal aid scheme, or for producing a new article in arbitration, or for any reform. I heard somebody saying that Indians are very peculiar people. I travel abroad quite frequently, and I said, what is peculiar about us? They said, you are against any kind of a change initially. Everybody would be up in arms for, it may be globalization, it may be legal aid, it may be any amendment in arbitration, any kind of a reform, you just oppose it. And then after some time, you embrace it in a big way. What is this? I said, this is very difficult to explain. But, and this is one big factor probably the legal profession need to look into, that delays are not because of the judges. Let me tell you very frankly. Judges are very keen to settle disputes in the courts as soon as possible. Delay is not because of the law schools, because we give you professionals. We give you professionals, but I'll come to that, what kind of professionals we give you, and what kind of professionals we need to give you. So the core person in the entire system who is a part of the justice delivery system, who is responsible for delay or for speedy justice is again the advocate. I think we need to put more and more focus on the kind of advocates we bring out, and ask more questions like what is the actual role of a law school. Now, is it the mission of the law school to go beyond producing technically competent and ethical lawyers? Does the mission extend to training lawyers to stand up for the rule of law, to work for law reform, to the community leaders? Is this a part of the professional responsibility? What is the impact of the globalization? Are we training lawyers for local, national, transnational or international practice? Some possible questions are, is it the primary task of the law schools to engage students in intellectual inquiry into the discipline of law, or to train lawyers for professional practice? If both, are these twin tasks of complementary opposed? How should this tension be resolved? Beyond ensuring graduates are technically competent, how important are the following goals? That is ethics, embedding a sense of ethical conduct and professional responsibility, as I said, quoting the Chennai incident recently. Rule of law, promoting a sense of duty as a lawyer to stand up for the rule of law, including the independence of the judiciary. Law reform, inculcating an inspiration to work for the improvement of the law and operation of the legal system and for achievement of the social justice. Leadership. What kind of leadership role the legal profession need to play in educating the leadership of the civic responsibility, and then in the globalized world? What is the universal and what is the culture bound by the values that underline legal education?
Honorable Justice Alkabe, Honorable Justice James Sahai, Professor Ranveer Singh, Vice Chancellor NLU, Delhi, CSP, SNP Sinha, Chairman Bar Council of India, Dr. B.S. Goyal, Chairman of the IPEM, Dr. Srivastava, Principal, District Judge, and other district judges, lawyers, professors of IPM, students, ladies and gentlemen, members of the civil society. It's my proud privilege to be here this morning to speak on a subject, justice delayed and justice denied. Fortunately or unfortunately, the history of the human civilization has all through had this problem of justice delayed, justice denied. And even up till now, we have not found concrete and suitable solutions to the malady of the justice being delayed and justice being denied. It's not the fate of this country alone while we are facing the problem of areas at default, the problem of justice not of the same quality as we expected or are expecting, the problem of the dispensers of justice not being up to the standards, and so on and so forth. We can name any number of the problems which the justice delivery system is facing, has been facing. I am reminded of Justice Holmes, one of the greatest saying, that what exactly you mean by that justice is delayed and justice is denied? What is justice? How does justice get delayed? And how do you feel that you are being denied justice? His response in the context of the United States judicial system was that if it is the law is what the pretensions of the judge are, then justice necessarily will get delayed. Because you don't have any other mechanism by which you can say that I am going to replace the court system. Whether you like it or whether you do not like it, the formal mechanism of the dispensation of justice has to take the recourse to the court process. Now that court process may be a Nyaya Panchayat, it may be a smallest magistrate executive, it may be the district judge, it may be the High Court judge, and it may be ultimately the apex court judge. That is how the process is arranged. No human civilization, down from the Romans down to the present, has ever had the possibility of developing something where we can have, in the present context, a slot machine, put the point and get the justice. It doesn't happen. But at the same time, when we are in the continuity of the human civilization, while we want to have progress, while we want to have inequities to be removed, while we want that the distribution of advantages vis-a-vis disadvantages have been monitored by a system, then what should be the merits of that system? That is where the dispensation of justice has to take care of itself. In that context, I am not going to speak on the areas of in the court, on the type of the judicial administration which we have in the country, because I am going to speak on those issues in my valedictory. Right now, if a list has to be drawn in the context of reforming the legal system, that is the judicial system of this country, important 4 variables are to be taken into account. The first is the Supreme Court of this country playing politics? If so, how they themselves have to avoid that politics? As an academician, I can tell you beyond doubt that the court, especially the apex court, has become a political institution. In what way? They have to devise mechanisms by which their politicization, that politicization has a definite connotation, that has to be dispensed with. That's first. Second is that the institutional hierarchy of the court system ultimately rested in the autonomy of the system as such. The Prime Minister is on record that there shall not be any dearth of or paucity of funds to be extended to the courts. Then, in what way the cases remain on the dock from 30 to 3 centuries? As our judge of the district court has said, that if no case in the criminal side is being instituted, it may take 300 years for removing the areas of the cases in the court. Obviously, therefore, the autonomous structure of this legal system, the dispensation of the judicial system of this country, has to think itself, because it cannot always accuse either the legislature or the executive for not its own promptings by which the dispensation of justice has to be carried to the door of the common man. Third, till this country remains illiterate, the half of the country is illiterate, the dispensation of justice will have its own premiums. Because what happens, that once you are illiterate, you do not know what exactly you mean by your case not getting the due, your rights not be getting the recognition, proper recognition which you want to have. In the ultimate analysis, if this country has to have the justice to be prompt, quick, efficacious, then necessarily illiteracy has to be removed. And how much time it is going to take, that itself has its own limitations. The last and important point, that is in the context of the present-day technological revolution, which is happening and has happened throughout the globe, the e-dispensation, the e-justice dispensation system, which has been put in practice in Europe. Indian judicial system needs to have it and try to explore the possibilities, whether through that e-justice delivery system, we can at least remove the areas from the court. The rest of the points which I have, which I will be discussing, that I shall put before you when my turn of delivering the valedictory address is being extended to me. Thank you very much. Thanks all.
Thank you so much, Professor A.K. Kaur. Ladies and gentlemen, it's my utmost pleasure now to request Professor Ranveer Singh, Vice Chancellor, National Law University, Delhi, to please come up to the podium and deliver his keynote address. Professor Singh has played a crucial role in reviving the legal education in the country and recasting it so as to make it more relevant to contemporary concerns. Ladies and gentlemen, Professor Ranveer Singh.
Honorable Mr. Justice Ahmed Kabir, Honorable Justice Sahai, Respected Mr. Sena, Professor A.K. Kaur, and J.L. Ghaziabad, members of the organizing committee, the other speakers, those who have come, Professor Mamta Srivastava, and other guests, dear students, media, ladies and gentlemen. I feel proud and privileged this morning being invited to be the part of this deliberations, which is a very important seminar on delays in justice. I have many questions to ask from myself and from you as well. The first question is, I ask, why I am here? Am I responsible for the delays? That is my first question. I'll answer that question later on. If yes, what is my role and the role of the law schools in the justice delivery system or dispensation of justice? I think we, all of the law schools, have to play a very big role as far as justice dispensation system is concerned. I'm reminded of what Justice Stone said, that the character of the bench is determined by the character of the bar, and the character of the bar is determined by the character of the law school. These all things are complementary. If you want to have good judges, you need to have good bar, good advocates. If you need to have good advocates, you need to have good law schools. Friends, if you know, the chairman of the Bar Council of India is here. We have around 700 law colleges in this country, and most of them are in the private sector. And sir, then we have about 400 universities, and in those 400 universities, which are state universities, central universities, and some of them deemed universities, we have about 30 or 40 law faculties, sir. And then at the top of it, we still felt the need of having the law universities. Why? Answer may be difficult, the answer may be easy. Out of these 700 law colleges, when I go for a NAC meeting and meet the faculty and the organizers of those institutions, I often ask, what do you feel is your ranking in these 700 colleges? Are you in the first 10? The answer normally would be no. So with these 700 law colleges, 130 law faculties, 13 law universities, the big question today is, delayed justice is fine, that what kind of lawyers we are producing. We are a great profession. Great profession in the sense that if you look into the history of any country of the world, not only India, you will find the lawyers have been always at the forefront to bring freedom to the countries. They have been a part of the freedom struggle. May it be Nehru, may it be Gandhi, may it be Patel, may it be Jinnah, may it be Nelson Mandela, may it be Lincoln. You have people all over the globe, those who were part of the freedom struggle and who were responsible for bringing freedoms to the countries. And recently you see Pakistan, our neighboring country. The democracy to Pakistan has come not because of anybody else. It has come because of the lawyers. We are a great profession, but then there is a big question mark. Incidents like what happened in Chennai, or elsewhere sometime, or when we waste times of the prestigious time, very prestigious times of the court, then we probably need to sit back and think, because these are all things which when the courts are closed for weeks, for months, for merely shifting a court or having a new court building, or for introducing a legal aid scheme, or for producing a new article in arbitration, or for any reform. I heard somebody saying that Indians are very peculiar people. I travel abroad quite frequently, and I said, what is peculiar about us? They said, you are against any kind of a change initially. Everybody would be up in arms for, it may be globalization, it may be legal aid, it may be any amendment in arbitration, any kind of a reform, you just oppose it. And then after some time, you embrace it in a big way. What is this? I said, this is very difficult to explain. But, and this is one big factor probably the legal profession need to look into, that delays are not because of the judges. Let me tell you very frankly. Judges are very keen to settle disputes in the courts as soon as possible. Delay is not because of the law schools, because we give you professionals. We give you professionals, but I'll come to that, what kind of professionals we give you, and what kind of professionals we need to give you. So the core person in the entire system, who is a part of the justice delivery system, who is responsible for delay or for speedy justice, is again the advocate. I think we need to put more and more focus on the kind of advocates we bring out, and ask more questions like what is the actual role of a law school. Now, is it the mission of the law school to go beyond producing technically competent and ethical lawyers? Does the mission extend to training lawyers to stand up for the rule of law, to work for law reform, to the community leaders? Should it? Is this a part of the professional responsibility? What is the impact of the globalization? Are we training lawyers for local, national, transnational or international practice? Some possible questions are, is it the primary task of the law schools to engage students in intellectual inquiry into the discipline of law, or to train lawyers for professional practice? If both, are these twin a task of complementary opposed? How should this tension be resolved? The old order, a new order, based on new jurisprudence, socially relevant and purposive. Are we not looking for a new order in the present context? And the students who are future lawyers have to be prepared for a special role in the society. They have to be prepared and modeled to be good advocates. The kind of advocates we need to prepare are those who are technically sound, professionally competent and socially relevant. For me, these three parameters are very important. You may produce best of technically sound lawyers, you may produce best of professionally competent lawyers, but if they are not good human beings, if they do not uphold, and in this perspective, they have to understand not only the legal rules, but also their socio-economic and political background, understand judicial, legislative and administrative institutions, and Professor A.K. calls that, understand their duties to the clients, to the courts, to the foreign lawyers, but also to the society. Understand not only the theory and the mechanism of disputes, but also access to justice. Understand law and also come out with suggestions to reform that the law becomes more humane. So it is in this perspective the role of the law schools become very, very pivotal, very, very important. Legal education, like Greek wisdom, should not only grow and blossom, but also bear fruits. Legal education and justice education has to be a guarantee for providing access to justice for the poor. The rich will take care of themselves. Don't worry about them. It has to meet the challenges of tomorrow, and it has to be an education by objectives. Legal education sets objectives, will neither serve the students nor the society in the long run. It is the first duty of the law schools to identify the objectives and strive hard to attain those objectives. We can no longer ignore poverty, pains, suffering of the weak, the downtrodden and the underprivileged, because it is that class which suffers most when the cases are delayed, when the justice is denied or justice is delayed. The vast gap has to be bridged. The task is enormous, but the famous Chinese proverb provides the answer, and that is within quote, even a journey of 1,000 miles begins with a single step. Let us take the pledge and abide by what Vivekananda, the great saint of India, has said, arise, awake and stop not till the goal is reached. The goal is the man, and I again quote, bored by the weight century he leans, upon his hoe and gaze on the ground, the emptiness of the age on his face, and on his back the burden of the world. The role of the law is to care for the uncared, to reach the unreached, to help the unhelped, if the justice has to mean anything to the common man. Let all the law schools join hands and take pledge to share the burden of the poor and to establish a just society based on just and equitable order and social order. The task is challenging, but the challenge is worth taking to make India a functional democracy and to regain the paradise lost before it is too late. Ultimately, the aim of teaching is not merely to increase the students' knowledge or increase the student number, but also to develop and enhance transferable professional skills in oral and written communications and self-presentation, teamwork, analysis and problem solving, all applicable not only in the workplace but also in everyday life. So the endeavor of National Law University Delhi as IPEM to bring the competent lawyer out, which has already present in all these students. In the end, I say I'm reminded of a very beautiful quote by Dostoevsky, where he says, this quote is at the ICRC Museum at the main gate, and the quote is that everyone is responsible to everyone for everything. I think this blame game has to stop. That lawyers would say that the delay is responsible because we don't have enough courts, or the delay because of the judges, or the judges would say it's the delay because of the legal profession, the advocates, or it lies somewhere else. Probably we need to find answers now and have a program where we will not allow adjournments, we will not allow stays, we will not allow frivolous litigation, we will cut down the government litigation. The litigation is by the government. I think there are very strong constituencies which are very apparent, where we work probably sincerely, the delays can be cut. With this, I take your leave and thank you very much for inviting me to this seminar.
Thank you so much, sir. Very indeed grateful for you.
Now it is matter of great privilege for law students. Dr. Tripathi, G.P. Tripathi, your author.
I will now request Mr. R.V. Sharma, ADs in Ghaziabad, to please come and present the bouquet to Mr. Suraj Narayan Prasad Sinha, Chairman, Bar Council of India. Ladies and gentlemen, please give them a big hand. Let's proceed further. I am particularly honored to request Honorable Mr. Justice Vijay Manohar Sahai, Justice Allahabad High Court, to please bless this august gathering with his special address. Ladies and gentlemen, Mr. Justice Sahai is a guest of honor at this seminar today.
Justice Altamas Kabir, Judge Supreme Court of India, Dr. B.S. Goel, Executive Director, IPEM, Ghaziabad, Mr. Suraj Narayan Prasad Sinha, Chairman Bar Council of India, Professor Ranveer Singh, Vice Chancellor, National Law University, Delhi, Professor A.T. Paul, Delhi University and former Vice Chancellor, National Law School, Jodhpur, Professor J.L. Kaul, Professor, Delhi University and advisor of the organizing committee, Mr. V.C. Gupta, District Judge, Ghaziabad, Professor Mamta Srivastava, distinguished guests, dear students. It is my moment of my pride and honor to be with all young students of this institute of national importance. It is also more gratifying for me personally to find amongst us Honorable Mr. Justice Altamas Kabir, the Judge Supreme Court of India, who has a unique personality to carry the audience with him in his public addresses. Our Constitution, in its preamble, brightly emphasizes to secure to all its citizens the three different concepts of justice: social, economic and political. By social justice, Constitution emphasizes in various articles removal of social disparity like untouchability, raising the standards of downtrodden segments of the society to bring them at par with other citizens and thus ensuring conditions for healthy competition with them. By economic justice, Constitution directs the state to take all efforts to promote the welfare of the people by creating a social order in which inequalities in incomes would be minimized and the ownership and control of the resources of the country would be so distributed so as to promote common good for all. It also directs the state to make an effort to prevent concentration of wealth. Thus, in short, economic justice aims at economic equality. By political justice, Constitution provides for equal participation of all citizens in all political process of formation and governance of the country. The principle of adult suffrage has also been duly recognized, and there can be no discrimination in respect of the rights of the citizens in casting their votes, whether based on religion, race, caste, sex, level of literacy, or of economic conditions. For achieving political justice, several fundamental rights have been specially articulated like speech and expression, right to assemble, and right to move freely throughout the territory of India. Given the requisite will and desire, all the citizens without exceptions are free to exercise their influence over policies and programs of the government by openly criticizing and even by opening appreciating it. It will be immediately realized that all the three forms of justice are permanent in nature and an ongoing and continuous process, and they have no terminals. They have only to be monitored continuously. However, today we are basically concerned with yet another form of justice, legal justice. Justice according to law for determination of legal rights and obligations of mutually contesting parties in a court of law, which is usually called as an adversarial system of litigation. Parties might reasonably think that their legal rights are being violated either by other parties or even by the state instrumentalities, and they want to get settled such disputes as quickly as possible. Such disputes of essentially private nature might be regarding their contractual rights, property rights, marital rights, compensatory rights, occupational rights, tenancy rights, rights arising out of service conditions or relating to torts. Even big companies and corporations, including international corporations, do have their own disputes for which they are particularly interested in getting a judicial verdict very quickly and efficiently. At the time of commencement of the Constitution, general societal atmosphere of such disputes was rather quiet and not very allowed. Cases were filed primarily in district courts, and then they attained their finality through the hierarchy of the courts. But fundamental changes in the judicial functioning became visible soon thereafter on account of a variety of factors, chief among them being enormous growth of population, a very large number of enacted laws, both at central and at the regional levels, enormous growth and evolution of administrative law, a relatively increased financial viability, and above everything, rapid growth of realization of the citizens about their fundamental rights under the Constitution. It became very apparent that their fundamental rights could be enforced through superior courts expeditiously without visiting the local courts and on payment of negligible expenses. Administration of laws and education of rights and liabilities did not remain the sole prerogative of the district level. Moreover, the judicial powers of the civil court came to be shared with various administrative authorities and tribunals, and which in various enactments closed the doors of civil courts by way of finality of their adjudication. Stringent enforcement at the cost of the denying justice only in order to expedite and to get quick justice. It is true that dictum has a great moral and ethical charm, that justice delayed is justice denied, but it should not become counterproductive to the extent that quick justice crucifies the justice itself. Because of justice only because courts are already too heavily involved in deciding even very old cases. We have to search for other ideal solutions to counteract the disease of delay. However, in my personal view, the Superior Court should use the cost factor strategy to control the unnecessary and directory litigation. The fear of payment of cost by any administrative agency by itself, which is adjudicating upon a dispute and which might be insulated from interference by subordinate courts. Although in all such cases, the concerned adjudicatory authorities are strictly speaking not courts but scrutinized judicial authorities, yet considering the nature of disputes and the litigants involved, situation is not very shocking. As far as delayed justice on the civil side is concerned, the primary reason appears to be that over a period of time, the functioning of these courts have not been sufficiently focused compared to the advantages derived from adjudication by higher courts. Cases are being filed before the civil courts with usual regularity, but the disposal is with undue irregularity. The reason also includes indifferent attitude of the litigant themselves, who file cases as a source of status and to prove their ego. In a very large number of cases, litigants have vested interest in keeping the cases pending for extraneous considerations. Courts are also not very enthusiastic in disposing such cases, especially because complicated questions are involved and there is no will or authority being imposed on them by superior courts. In the process, adjournments after adjournments are too liberally granted, which suits the litigant and including the courts themselves. Even substitution applications are kept pending for years for their disposal, and on many occasions they are being followed by fresh substitution applications. Provisions of appeal and revision at intermediate stage of a suit and a consequent stay of proceedings of the entire suit have their own unfortunate take, and this essentially puts a roadblock in the quicker adjudicatory process. At the top of it, as the saying goes, even after obtaining a degree finally after the resort to various courts, to get the degree executed is a more arduous than getting a degree itself. Recent concern of the Parliament has been widely acclaimed, but its steps are likely to bear fruits gradually. Thus, mandatory provisions regarding adjudication through alternative dispute redressal under Section 89 CPC are highly innovative and particularly resolution of disputes through arbitration is now globally recognized. Provisions restraining unnecessary adjournments, serving of summons, filing of written statements within a definite time schedule, restrictions regarding filing of revisions at intermediate stage of suits have great deterrent value to counter the delay factor, and it is fairly expected that all courts would pay full and due regard to these amendments. However, as I have already pointed out earlier, unless the parties themselves are also the courts fully realize the importance of quicker dispensation of justice, these efforts would remain a cry in the wilderness. The fact has to be realized by all concerned that for achieving efficient and quicker justice, a little compensation imposed by the courts on the parties goes a long way to help people at large. Superior courts should expressly encourage such a course of action undertaken by district courts. I might also suggest that an efficient administration by the Allahabad High Court monitoring of cases by classifying them in different but common categories of their own would constitute a very pragmatic and healthy exercise. Thus, different nature of cases involving civil disputes like contractual disputes, property disputes, matrimonial disputes, personal law disputes, succession law disputes, disputes regarding compensation, damages, landlord-tenant disputes, etc. may be grouped separately and assigned to the judge having expertise for those particular branches. And above everything, a balance between fresh cases and old pending cases must be maintained in such allocation of work so that old and pending cases do not lose their importance. Furthermore, creation of essential infrastructure is the minimum and most important requirement at district court level. Without any delay, necessary funds must be directed to be allocated by our apex court exercising powers under Article 142. Number of vacancies have to be increased. They are to be filled up at appropriate time. Court buildings and rooms should be given a decent look, and the atmosphere of the grandeur of the civil courts has to be created in the mind of general public. Provisions regarding adequate staff, books and journals and judicial training of judges can no longer be treated as anything but minimum requirement for efficient operational justice. Fortunately, very recently, a very welcome step has been taken by the executive to raise the salaries and allowances at all hierarchical levels of the court. But it must not be regarded as a gift, but as a true measure for strengthening the justice delivery system. It is the administration of justice on the criminal side in subordinate courts that judicial scene is really tragic and appears to be utterly defenseless. Although an accused is presumed to be innocent, lakhs of people, including young children and ladies, and even very old people, are thrown behind bars for no fault of theirs, even for very petty crimes, for the reason of their illiteracy and total financial disability to defend themselves. Our jails are enormously overcrowded. The procedure on criminal side is so dilatory that rich and influential are inherently capable of exploiting the same. They are able to get acquitted even in case of apparent culpability, or at least they are able to get lighter sentences. They are so able to mount the judicial process that they effectively and substantially delay the final verdict. Witnesses against them are threatened, assaulted, or even killed, and unfortunately, state is unable to protect them. One can easily find the unfortunate scene of witnesses retracting their testimony before the court of law time and again. At various hierarchical levels, number of criminal cases are pending, waiting for their final verdict, irrespective of the fact whether the case pertains to the domain of acquittal or punishment, whether the punishment is very heavy like capital punishment or imprisonment for life or lesser punishment, whether the accused is already in jail or not, and the period of such freedom or the lack of it. Since criminal adjudication are fact-oriented and time-consuming, there is normal apathy on the part of everyone concerned not to give judicial verdict quickly. Recently, innovations including establishment of fast-track courts have certainly improved the situation, but a lot remains yet to be achieved. Various amelioration measures are urgently required. Thus, a large number of judges at every hierarchical level should specially be appointed and designated for only such cases. There must be an effective time schedule for them to dispose of the cases, which should be strictly followed. Measures for protection and physical safety of the witnesses are immediately required to get a fair trial, and a special law in this regard must be immediately enacted. Similarly, there should be classification of cases, classifying them into nature of offences and quantum of punishment, and such cases should be disposed of by these judges having special expertise in them. In my considered opinion, nature, literacy and financial viability of an accused must have a great regard to the mind of the judge for the purification of criminal law, although as a matter of rule, these factors generally act as detrimental to even a very innocent accused. Thus, for an accused with such restraint bail should be the rule rather than jail. Criminal part of judicial governance must be given the highest priority, not only in view of the fundamental right of a person under Article 21, but also on the footing that he has natural and inalienable right to live with human dignity and to contribute to welfare of the society even with his very limited means. At the end, I must conclude by saying that it has taken too long a period to realize the present balance of the delay in administration of justice, but the remedy must not be worse than the disease. Once we are able to identify and control the real causes, given sufficient will and consciousness of the litigants, people and the courts over a period of time, the situation is bound to diffuse. However, it is not necessary to be panicky even in the face of the present day grim reality. We must recognize that it is a challenge thrown to our entire judicial functioning, a challenge thrown to all of us, and so this solution can also be found by all of us by taking all our joint efforts. No particular segment of the society, neither a lawyer, nor a judge, nor the litigant, nor the legislature, nor the institute is to be blamed specifically. Thank you all.
To come onto the podium and deliver his inaugural speech to this humble gathering. Your Lordship, Justice Kabir is a renowned face of the judiciary in India and is being seen in high esteem in Indian legal circles. Ladies and gentlemen, Honorable Mr. Justice Kabir.
Thank you very much. Mr. Justice Saheb, Judge of the Ghaziabad High Court, Dr. Goel, Professor Ranveer Singh, Professor Kaul, Mr. Senna, Chairman of Bar Council of India, the Director of the Institute of the Law Academy of the IPEM, Professor Mamta Srivastava, Principal of the Law Academy, members of the District Judiciary present here, students, members of the faculty, friends. I'm happy to be here today on an occasion when a topic which is being discussed over and over again has again been brought up for discussion, because this is something which needs to be discussed often. This is a topic which requires consideration every few months, every few weeks, I would say even every few days. The problem of delays, the problems of piling up of cases is a problem which we are facing each day. Why it is happening is something which requires to be analyzed. Why it is happening is something which we need to identify in order to come to or find out solutions towards lessening this problem. It's no use trying to blame people or blame somebody or the other for what has happened or what is happening today. Without a blame game, one will have to find out ways and means of trying to resolve this problem, which is gradually becoming, I am sorry to say, although Justice Sahay was very optimistic, I would say that this is a problem which seems to be gradually getting out of proportion. Justice delayed. What exactly do you mean by justice? This has been in the introductory speeches by the other speakers. They have dealt with this. Justice would possibly mean to a common man, to a little speakers. They have dealt with this. Justice would possibly mean to a common man, to a litigant, the ultimate final result of the litigation he has instituted, or a complaint which he has made which needs to be resolved. The ultimate result, that would be justice to him or her. It's not justice of an interim nature. It is justice of an interim nature which, in fact, in my view, causes delays. At the same time, one cannot also do without it. There are situations where interim orders are required to be made and passed. Not only in an original proceeding, but at the 11th stage. So if one has to deliver justice to the common citizen, it has to be the final decision that is arrived at in his proceedings. To each individual, his case is the most important. A person may be from the lowest rung of society, economically or otherwise, and a person may be from the highest rungs, makes no difference. To that person, that man, his case is the most important, and he wants a finality. It may go against him, it may be in his favor, but he would like to see that it ends within reasonable time. Let me give you one or two examples from my own experience as to what could be the meaning of justice delayed is justice denied. When I was a practicing advocate, there was a case where there was a dispute over a certain property. One of the parties to the dispute went to the criminal court. Mind you, went to the criminal court and not to the civil court. Filed an application under section 144 CRPC. Obtained an order to prevent anybody else from interfering with his possession there. Whether he had possession or not, it made no difference. He obtained an order. The person in possession, he found that the police suddenly came to him with the order of the court saying you are disturbing his possession. He says, but I am in possession. He says, no, that will not do. You go and get an order from the court also. Very well. So the other person went to the court. Same magistrate, same 144, same order. Same magistrate, same property, two different persons saying two different things, same order. Now the police says, he is not to be disturbed, you are also not to be disturbed. Then what happens? Then the other factor came into play. Who had more resources? And the person who had more resources, naturally he prevailed, and his work started. He started construction on the site. There was no other alternative. The other party had to come to the High Court. Came in division, came to the High Court. Having regard to the urgency of the matter was heard at a reasonably early date. By that time, already the foundation had been laid. The matter was heard, adjourned. By that time, the first story was raised. Finally, the matter was finally heard. Judgment was delivered after 4 months. By that time, the complete structure had been raised. This would be an example of justice today is justice denied. A fait accompli had been created from where one could not return. Let me not ask you, let us not ask ourselves, who was to blame? It happened. It happened from the lowest rung up to the highest rung. This is one case. This is just some food for thought. Another personal experience. I was in Jharkhand for a brief spell as Chief Justice. As Chief Justice, I decided to visit all the districts if possible. Jharkhand had 23 districts in those days. I went to the various districts and I happened to be in Delhi on one occasion when there was a conference with regard to various matters of which in fact amendments to the Civil Procedure Code to which extensive reference has been made by Justice Sahai was one of the topics. My wife was with me and she is very interested in visiting children's homes, destitute children's homes, observation homes, remand homes. And while I was at the seminar, she had come to the remand home in Devghat for girls. After the seminar was over, or rather in between when we adjourned for lunch, she came to me and said, would you please find some time to come and visit the remand home or the observation home? I said, fine, we go. So I went there. And when I went there, one girl came up to me. She must have been about 15 years old, 15 or 16. She said, sir, can you help me? I said, why, what has happened? She says, I don't know why I'm here. From where she had come. So her identity was that little strip of paper with a name on it and nothing else. Then we had to try and find out where she was from. Then I put my machinery into action. Finally, we found that 7 years prior to that date, she had been found on the Patna railway station platform. She was a little girl of 7 then, and she was there. And she had been caught by the GRP, the railway police, for not having any document. By a document I mean a ticket, either a railway ticket or a platform ticket, to be on the platform. Very well. So she was taken to the railway magistrate, done in accordance with law. The railway magistrate, in his turn, sentenced her to pay a fine of rupees 300. In default, to suffer 15 days of detention in the Nadi Niketa. This is what we found later on from the records of the railway magistrate. That girl was brought there when she was 7 years old. It was quite impossible for her to pay 300 rupees fine. She was there as Anybody who goes to a railway platform, possibly she was there as a pickpocket also, or as a pickpocket trainee. One never knows. But certainly not as a passenger. She didn't have a platform ticket. Very well. She was brought there, that slip of paper was put in the file, thereafter she was forgotten. She lost 7 years, or let us say 8 years when I was there finally, of her childhood. And when we asked why this has happened, having been the Chief Justice, I had the privilege of taking the matter on my own file, on my own motion, and I took it up. And I called the Advocate Generals of both the states. By that time, Jharkhand had been created. Devghar was in Jharkhand. Patna was in Bihar. Called the Advocate Generals of both the states. I said, where does this child's family live? Why is it that for 7 years she's here? Nobody had any answer. Naturally, nobody could answer. Once the child is dumped there, the matter ends. The job of the administration is over. We said, no, that will not do. Find out where this child's parents are. She has to be restored to the parents. After about 2 weeks, sorry, Madhav, we were not able to find out anything. I said, you go and find out from the description that she's given as to which village she belongs to. Finally, they did find out. The parents had both died in the meantime. There was one brother who had gone away to Assam. Find him. After 1 month, they still couldn't find him. Then I said, that will not do. I said, unless you find him within a week, we shall take steps. Within a week, not only was the brother found, but the child was also restored to the brother. After 8 years, the child not knowing what had happened, she was restored to the brother and she had lost her child in the meantime. Is this justice? Who was responsible? Don't ask. Somebody had to find a solution to this. A small little third example. In Delhi, there are these juvenile justice boards. 2 of them are there. Those who are familiar with the Juvenile Justice Act would know that a minor who is under 18 years old can be punished only in a particular way, even for the most serious of crimes, even matters relating to murder. The maximum punishment is 3 years, and for other cases, normally a case is to be completed within 4 months. Here we find a child, maybe about say 6 or 7 years old, having stolen a banana from somebody's shop, maybe a few biscuits from somebody's shop, a hungry child, a loaf of bread. There the police had to lodge a complaint, an FIR, under section 379. This was about 5, 6 years ago. And after 5 or 6 years, the child was still there for having stolen a banana or a biscuit. Is this justice? Is this justice delayed, justice denied, or whatever you call it? There are children I've seen who have grown up, they have become children, they have children of their own, but they're still attending the Juvenile Justice Court where the cases are still pending. These are just by way of example. I'm saying this is, if you say justice delayed is justice denied, this is just a little sample. There are thousands of people having the same problems. The question is, what do we do about it? It is not that as if people are not sensitive, people are. It is not as if the legislature couldn't care, they do. But then again, whatever we do, whatever they do, whatever we have to implement, it has to be done by us jointly, as very rightly pointed out by all the speakers before me. Section 89 of the Civil Procedure Code was there in the CPC earlier. It was deleted in 1939 or 1934. It was deleted. But because of this kind of burgeoning cases and the delays, it had to be reintroduced, the amendment in 1972 or 73. It had to be reintroduced. What has been brought in by Section 89? A duty has been cast on the civil court at the lowest level to see whether a matter could be settled at the earliest stages. If a settlement could be arrived at, then the matter, the terms of settlement could be framed and the matter could be sent to either the arbitrator or to the mediation center or to the conciliator, so that things could be worked out. And one other very important organization or an institution was also included, and that was the local adalats. Having regard to this growing number of cases and the fact that one adjournment in a particular case could have a cascading effect. One adjournment today means the matter has to be adjusted against another day. When there's another pile of cases, this piles up, having a cascading effect. It all piles up together and it becomes unmanageable. How much can one magistrate or how much can one landed civil judge junior division do in a day? If his docket consists of even 30 matters, where he has to dispose of, say, small little things like substitution applications, amendment petitions, then a little bit more serious things like applications for injunction, receiver, then suits, hearing. How much can he tackle in a day? One has to be also reasonable and think as to what a person's capacity is. And just as you say, justice delayed is justice denied. Don't forget there is a converse also. Justice hurried is justice buried. Now what is important is to be able to strike the middle path, strike a mean, strike a balance, where you can manage your court in such a way, case management, in such a way that you're able to deal with certain matters within a certain time and other matters, devote other matters for other purposes. Alternate dispute resolution mechanisms, formation of tribunals, all these have become part of the system today. What was the functions of the courts, they have been now distributed amongst various tribunals and bodies. Let us hope that something comes out of it. But as far as I understand or know, even the tribunals, they are also clogged with their work. It's not that they are wielding some kind of a magic wand. They are doing the same work. Ultimately, it boils down to the same thing. I'm quite aware that well, we have gone beyond the time limit. There was so much more to talk about, but then maybe some other day, some other time, we'll have the opportunity. Thank you very much.
Thank you, Justice Sports, and throughout in sport education.
Thank you very much. Honorable Mr. Justice Kabir, Judge of the Honorable Apex Court, Mr. Justice Sahaj, Judge of the Honorable High Court of Allahabad, Professor Ranveer Singh, Vice Chancellor of Delhi National Law School, Dr. Goyal, the Executive Director of this institution, Professor A.K. or ex Chancellor of Jodhpur National Law School, Professor S.P. Singh, Director of this institution, Dr. Srivastava, the Principal of this college, and the other faculty members of this institution, the press, dear students, friends on the dais and off the dais, ladies and gentlemen. I was really thinking to talk on the subject which is of prime importance at the relevant time. But the speakers on the dais, they have elaborately discussed the matter: justice delayed, justice denied. We have just now heard Honorable Justice Altamas Kabir, justice hurried is also justice buried. Therefore, these are the two hard facts which have got to be solved. Justice should not be done in hurry, it should not be delayed. These are the facts, and you know at during the period up to 2006, there has been number of cases which are mounting in courts. The Supreme Court and the High Courts have been directing the courts below to expedite the cases, giving guidelines, all these things. But you have seen the disposal is lesser than the institution of fresh cases. Therefore, mounting of cases is the phenomena which is every day increasing. Therefore, rightly it has been said by some of the honorable judge that it will take 300 years to dispose of the backlog cases. But we have to evolve certain principles. There has been some amendments in the CRPC and other provisions in the CPC also. Plea bargaining in small cases. Let the accused come and confess the matter and the court will decide it immediately. But there are certain difficulties in that also. Be that what it may be, I had the occasion to witness the court proceedings in so many foreign countries, and the data which have been collected will show that in foreign countries also, in USA, in England, there were mounting cases, but they have evolved certain formulas for disposal of the cases. In America, you will find that the cases are resolved in the chamber of the lawyers, small cases of course, and they are resolved in the chamber of the councils, and the decision is arrived at with the consultation of both the parties. The parties give in writing that this is our decision, and the honorable judge puts his signature, signs it, gives one copy to the other this side and the other copy to that side. It is disposed of in the chamber of the lawyers. Lawyers are one of the pillars of justice. We, the lawyers, are also responsible in unnecessary taking adjournments, playing to the court at times. In the recent past, there has been disposal of number of cases in the subordinate courts and also in the high courts. Tamil Nadu has taken the lead in disposal of the case, and Ghaziabad High Court and its bench in Lucknow, they are second in number in disposal of the case, the highest disposal of the case in the country. Therefore, look here, the judges are not only responsible for delaying the justice, but the lawyers are also responsible for that, I must confess. And there are lawyers here in the court. I will advise them that please try to settle small cases outside courts by conciliation, by mediation, by any process, so that the court's burden may be lightened. This is our pious duty. You know that our country is a poor country. Millions of people are illiterate. They don't know their rights. They have got to be taught. What are their rights? What are their duties? And the young lawyers who are coming today, they should come forward to teach them, because they are the users. Most of them do not know where to go, where to seek justice. Now it is for the lawyers to. So the honorable judges who take cognizance of an offence, at the time of taking cognizance of the offence, must visualize, of course, the High Court and the Supreme Court of India says, look here, at that stage you have to look to the pinhole and nothing else. You have to, but at the same time, the Supreme Court has said times without number that only two witnesses coming in the court and saying X has killed Y, the court will only issue process. You must gauge whether the case is true, the case is false. You can judge by cross-examining the witness in the dock yourself. So false cases may be dismissed at the initial stage itself, and the person coming to court filing false cases should be penalized with heavy cost. Then, of course, the litigants will be very careful in coming to the court with false cases. And the lawyers are also to be advised by us that if you come across that somebody is coming to file a case against his rival, false case, please don't advise them to come to court. The judge who decides the case, he has got to see that as a matter of fact whether the case is false. And if the wrong is punished, well, it will be great injustice to the humanity, to the society. Therefore, what I want to suggest, that there must be such formula, it may be evolved, that petty cases should be decided outside court, so that the number of cases may be lessened, the burden of courts may be lessened. Besides that, you know what is the percentage of the judges in our country? The percentage of the judges goes up by 40%. The government comes to it. For that purpose, the government has to come. They have to create infrastructure, they have to create buildings, they have to appoint judges, they have to give financial assistance. All these things have got to be done in a democratic country. In other countries, what has happened, you see, I have got the data. USA has enacted the Speedy Trial Act of 1974, requirement for timely prosecution and disposal of criminal cases. Likewise, we can also have such legislation in the country. It is for the parliamentarians to do it. they should evolve such mechanism that a particular case is decided within a framework time. There has been fast track courts, cases are being disposed of, but number of cases are disposed of and more than that are being filed. These are the reasons of filing of cases. In other countries, like you see, the ratio of judges per million population in the country is the lowest in the world. This is the data. The population and judges ratio in India is 13.5. Judges per 10 lakh people, as compared to 150 to 150 per 10 lakh people in advanced countries. So 13 here for 10 lakhs and 130 to 150 for 10 lakhs in other countries. So these are the ratios, and there is a very big ratio, not a small. In other countries, like the ratio of judges per million of population is about 58 judges in Australia, 75 in Canada, 51 in UK, and 107 in US. These are the ratios, and look to our figure 13.5%. So the number of cases is bound to increase. Backlogging will go on piling. It can't be reduced unless judges ratio is increased. You will be surprised to know that average disposal per judge is about 1300 cases in subordinate courts. If calculated on the basis of disposal and working strength of judges in 2006, this is the data which I have collected in 2006. The average disposal of all India High Court is about 2400 cases per year. The national average of disposal of cases per judge per year is in major high courts is Kerala, 3,000 and odd. Madras, 2,000, about 3,000. Calcutta, about 3,000. Punjab and Haryana, about 3,000. Karnataka, 2,000 and odd, and Andhra, 2,000. So in other states, the ratio is less. In this way, what I want to suggest is that the backlog cannot be cleared without additional strength of judges. To tackle the problem of backlogging within a time frame, we need to allocate additional funds for employing additional judges. In this way, we can anyhow control the backlogging. I strongly believe that inadequate judge strength is one of the problems in disposal of the case. I will appeal to the Government of India and all concerned that there must be appointments in the higher judiciary as also in the lower judiciary, so that the cases which are piling up every day must be reduced, and the alternative remedy has got to be thought of, that the matters, small cases are decided outside court, and if they want judgment from the court, decide it and file a petition of compromise like this, and please sign it, the judge will sign it, it will be decreed. So in this way we can reduce the number of cases. While parting, I thank all the faculty members and the organizers of this seminar, which has been a great success. And while going, I will only chant one couplet. सूरज हूँ, जिंदगी की उमक छोड़ जाऊंगा। सूरज हूँ, जिंदगी की उमक छोड़ जाऊंगा। अगर डूब भी गया तो शफक छोड़ जाऊंगा।